In the matters 23 CF 172, 24 CF 208, 24 CF 208, I guess for two. We're here with State of Wisconsin versus Joseph Berg. We have the state appearing through District Attorney Kevin Schmidt in person. Mr. Berg appears in person with counsel Daniel Chapman. We're set today in these matters for a plea hearing and an arraignment. Before we proceed, are we in victims' rights compliance?
Yes, sure.
With regards to the arraignment, Mr. Chapman, were you able to go over the criminal information with Mr. Berg?
I did not specifically discuss it with him today, but he is well aware of the charges from previous discussions, and we were prepared to go forward with the plea today.
All right.
Right from the start, this case moves fast. Multiple felony files, a global plea agreement, and a defendant facing serious firearm and bail jumping charges. The court is making sure every procedural box is checked, but don't let the calm tone fool you. This deal involves prison exposure, lifelong firearm restrictions, and a judge who makes it very clear she is not bound by any recommendation. The real question is, did this plea actually protect the defendant or lock him into something far worse at sentencing?
So at least at this time, not guilties on
Yes.
those. Not guilty pleas will be entered on his behalf as it relates to those. We're here for a plea hearing now, a global agreement. Can you please recite the agreement for the record?
Your Honor, Mr. Berg will be pleading guilty to felon in possession of a firearm in 23 CF 172 and to felony bail jumping in 24 CF 208, specifically count 1 for failing to maintain absolute sobriety. There will be a joint request for a PSI, and at sentencing, the state has agreed to cap its recommendation at the DOC's recommendation. The defense is free to argue.
All right. Okay. And Mr. Berg, that is the agreement that you've reached?
Yes, Your Honor.
Okay. With 23 CF 172, you did say we are in victims' rights compliance?
Yes, sir.
Okay. I just wanted to make sure. And basis for the agreement and why it's in the public interest, Mr. Schmidt?
I think it's appropriate given the facts of the case. It includes a high felony with the felon in possession of firearm. It's a decision I made after after reviewing the body cam and specifically how the drugs were affecting Mr. Berg on the body cam.
This is the point of no return. The judge meticulously walks through the constitutional rights being waived. Trial, confrontation, silence, all gone with a guilty plea. But what stands out most are the lifelong consequences, permanent loss of firearm rights and suspended voting rights until restored. This isn't just about prison time anymore. It's about civil rights, future limitations, and how one plea reshapes the rest of a person's life. The court makes absolutely sure there's no confusion, because after this, there's no undo button. Do you think body cam evidence like this should carry more weight at sentencing, or should it be limited to determining guilt?
It kind of showed him in a rigid, non-responsive standing state for a long time until it started, whatever he was on wore off, and then he got confused and didn't know where he was.
Okay. All right. Thank you. So, Mr. Berg, I have in front of me a plea questionnaire waiver of rights form. Do you recognize the document?
Yes.
Did your attorney go over this document with you thoroughly?
Yes, Your Honor.
Did he essentially go over it with you word for word?
Yes.
And you understood everything on that document?
Yes, Your Honor.
Is that your signature on the second page?
Yes.
You were pleading guilty to one count of felon in possession of a firearm in 23 CF 172 and one count of felony bail jump in 24 CF 208. You are 38 years old. You have 10 years of schooling. You can read, write, and you understand the English language. No drugs, alcohol, or other medications other than a prescription medication within the last 24 hours?
That's correct.
And have you taken that prescription medication as prescribed?
Yes, Your Honor.
And is that a prescription that interferes with your ability to comprehend or understand anything that's going on?
No, Your Honor.
So you are in a state right now where you completely understand and comprehend everything?
Yes.
Now, did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
Because you're being charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on that first page of that plea questionnaire. Did your attorney go over those rights with you?
Yes.
Did he go over them thoroughly with you?
Yes.
And do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you also understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand with 23 CF 172, possession of a firearm by a felon, the state would have to prove on or around September 16th, 2023, you possessed a firearm in Burnett County, Wisconsin, having been convicted of a felony in St. Croix County, in Wisconsin, cases number 17 CF 262, 15 CF 199, and 04 CF 335, and in Washburn County case number 09 CF 92. So do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $25,000 or imprisonment of up to 10 years or both?
Yes, Your Honor.
You also understand that with regards to the 24 CF 208, the state would have to prove on or around September 7th, 2024 in Polk County, Wisconsin, having been charged with a felony in Burnett County case number 23 CF 172, and having been released from custody, you intentionally failed to comply with the terms of your bond by maintaining absolute sobriety. Is that the one he's pleading to?
Yes, Your Honor.
All right. And so do you understand what the state would have to prove?
Yes.
Do you understand that upon conviction, you do face a fine of up to $10,000 or up to 6 years of incarceration or both?
Yes.
Do you also understand that there's a recommendation to the court here, a joint recommendation for the court to order a pre-sentence investigation report in which the state is capped at whatever the Department of Corrections recommends for sentencing? Do you understand that I'm not bound to follow any recommendations?
Yes.
And do you understand what that pre-sentence investigation report is?
Yes.
And it's going to give me a whole lot of information, as well as the attorneys, about you, about your life, about your criminal history, about your upbringing, mental health, physical, all of those things, with that recommendation for sentencing from the Department of Corrections. So you understand I'm not bound to follow the Department of Corrections recommendation.
Yes.
And I'm not bound to follow the state's recommendation.
Yes.
Or the defense's.
Yes.
And so do you understand that I, in my discretion, can sentence you to the maximum possible penalties for each of those charges if I find it is warranted?
Yes.
Do you still wish to proceed and enter guilty pleas?
Yes, Your Honor.
Do you understand that you're pleading guilty to felonies? As such, you will no longer be able to use or possess a firearm for life.
Yes.
You will no longer be able to vote in any election until your civil rights are restored.
Yes.
This is the point of no return. The judge meticulously walks through the constitutional rights being waived: trial, confrontation, silence, all gone with a guilty plea. But what stands out most are the lifelong consequences: permanent loss of firearm rights and suspended voting rights until restored. This isn't just about prison time anymore. It's about civil rights, future limitations, and how one plea reshapes the rest of a person's life. The court makes absolutely sure there's no confusion, because after this, there's no undo button.
Did you go over both of those criminal complaints with your attorney?
Yes.
And in particular, there is that section in both of them called the probable cause section, where it basically says what happened those days and why you were charged with crimes.
Yes.
And for the most part, as it relates to the two charges you're pleading guilty to, are those facts accurate?
Yes.
Are you admitting that you did, in fact, possess a firearm and you are a felon?
Yes.
Are you admitting here today that you, in fact, did violate intentionally the conditions of your Burnett County bond?
Yes.
Are you pleading guilty to those charges because you are guilty of those charges?
Yes.
Mr. Chapman, may the court use the probable cause section of the criminal complaints to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to these charges?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at these matters thoroughly?
I assume so. It seems that way.
Has he discussed with you the facts of this case
Yes.
and what the state would need to prove?
Yes.
And did he discuss with you any potential for any defenses or possibly a lack of defenses in the cases?
Yes, Your Honor.
And so he negotiated on your behalf and he came up, he got this agreement with the state?
Yes.
And are you satisfied with his services?
Yes.
Do you have any questions for the court or your attorney before I proceed?
No, Your Honor.
Then as to 23 CF 172, possession of a firearm by a felon, how do you wish to plead?
Guilty.
As to 24 CF 208, count 1, felony bail jump, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 2 charges. The other counts and charges will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. And just briefly, quickly, Mr. Chapman, because there was a time where Mr. Berg may or may not have been there during the incident of this matter. Do you believe he's competent right now to enter these pleas?
Oh, yes. During the incident, it was drug and alcohol related, in my opinion.
And he's doing great since then.
I have never had any question about Mr. Berg's competence.
All right. And you believe he's entering his pleas freely, intelligently, and voluntarily?
Yes, he is.
Full understanding of the facts and what the state needs to prove?
Yes.
And any potential defenses or a lack of?
Yes.
All right. Okay, then the judgment of conviction is entered and the court is going to order a pre-sentence investigation report. Long form agent does not need to appear, but should be available by telephone if questions are needed to be answered. As to bond, I'm going to guess you're not asking to revoke bond at this time, Mr. Schmidt?
I am not.
Bond will remain active. You are under all of those conditions of bond. If you violate bond, I'm letting you know right now that gives the state the ability to do what they want with regards to arguing. Right now, they're capped at the PSI, so follow your bond to the letter, okay? And
Yes,
when the DOC, Department of Corrections, contacts you for your input in this, you are ordered. You have to comply with them. It's only in your best benefit if you do. I just need to make sure that I have your address is still on Valley Drive.
Yes.
And telephone ends in 3623.
No, Your Honor.
May I get an updated?
It is 612-528-8330.
May we send you text message notifications if we need to?
Yes.
Okay, so I'm not revoking bond at this time. I'm ordering you to comply with DOC. You must report immediately after here to go to DOC just to make sure that they have your info and all of those things, but they should. They may or may not want to get started today. I'm not sure, but since you're coming from such a distance, that's why I'm saying you should just go report today, see if they want to have any contact.
Where is that?
It's kitty corner from the courthouse.
Okay.
You should be able to see it when you go towards Webster. It's on your right.
Okay.
Okay.
Just pull out of the parking lot, turn left, and it's right up
We
there,
need a
right?
date for sentencing. And Mr. Chapman, it's going to go into the new year. Is that okay?
Oh, yes.
I can do January 6th. Wait, did I sentence you? No. I can do January 6th, either at 9 or at 11 or anytime in the afternoon, or January 7th. Oh, wrong week. Sorry. I need to look at a Schmidt week. I can do January 20th, or I must have had something come off because the week of the January 20th, 21st, 22nd, and 23rd, I'm wide open.
That's still Jose's week.
Oh, darn it.
He did the week of the 12th.
I know, but I have, we're booked solid. Well, I guess January 26th, can you do 1 o'clock?
No, Judge, I need to be in Polk County at 1 o'clock. I am back in front of you at 2:30.
I guess I can take off my prelims. I can do it at 3. Do 3 to 4. All right.
Just so you know, Judge, Mr. Mr. Berg is on probation and doing well right now from his Polk County matter. So
I thought he had his sentencing.
if you're trying to think, I have to get this done as soon as possible, and you're trying to squeeze in prelims, I think we're fine waiting, but
My thought was not trying to get it done as soon as possible, but victims
understood.
trying to get it done as soon for any victim involved, so. that's
Okay.
all.
The January 26th at 3:00 is just fine.
Okay, we'll see you then, January 26th, 3:00. Follow your bond to the letter, okay? All right,
Best thing you can do.
anything further, Mr. Schmidt?
No,
Mr. Chapman?
No, Your Honor.
All right, then we are adjourned.
I don't know if it's been part of the court's thinking or if it's been, Commissioner Krupa's other things, but
You call if you need.
our office is able to be double booked again on Thursday.
In the end, the court accepts the guilty pleas, orders a full pre-sentence investigation, and leaves sentencing wide open. While bond remains intact for now, the warning is crystal clear. One violation and everything changes. This case highlights how plea deals can resolve charges quickly, yet still carry enormous long-term consequences, depending on the PSI and the judge's discretion. Sentencing will ultimately decide whether this agreement was a strategic move or a costly gamble. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and subscribe for more in-depth, no-nonsense courtroom breakdowns you won't see anywhere else.